This is my opportunity to show you what the evidence will demonstrate in this case. And in making my opening statements to you, I put together some visual aids that I'm used to using because when I was an attorney, we didn't have overhead projectors. They call it Chronicle now. And I am technologically challenged in that regard. Now, the first item that I'm going to show you is just a visual aid. It won't be an exhibit that's marked in here. It's just something that I prepared so that you might follow my initial remarks. I would state that the attorneys general in this matter have looked at these. And this crude visual aid here will kind of show you the history of what's going on here once you get an explanation. The evidence will show that there is one piece of property with two names that's relevant in this case. One of the properties is 600 Broadway. The other property is Whiteacre North Limited Liability Company. The evidence will show, ladies and gentlemen, that in the year 1984, I had left the partnership and was looking for a place to practice myself. The evidence will show that in 1985, the old Lorraine National Bank building at the corner of 6th Street and Broadway Avenue was vacant. The evidence will show that my wife and I, Susan, took advantage of that and we purchased the building. The evidence will show that we remodeled the first floor and that there would have been offices for 3 lawyers. Important to the case is the fact that Attorney Michael Tully, from 1985 and thereon, rented space in that building, and we were sort of office associates. And that took place between 1985 and 1997. Attorney Tully was simply a tenant in the building. It was 600 Broadway, and there was no such thing as Whiteacre North. In 1997, the evidence will show that Attorney Tully and I, and my wife, and an attorney named Sam Bradley, decided that it might be a good idea to fit up the entire building. Attorney Tully and I were simply on the first floor. The evidence would be that that's all I had remodeled by 1997. With that in mind, we formed a limited liability company. The evidence will show that the contribution that my wife and I made was the assignment of this piece of real estate at 600 Broadway to this new limited liability company. The evidence would show that Attorneys Bradley and Tully then, in consideration for our transfer of this property into the new company, were required to pay us a sum of money. And we continued in that regard. Somewhere between 1997 and 2007, the evidence would show that Attorney Bradley dropped out of the partnership. As well, it will show that in the year 2006, I decided to run for the office of judge. Because I wanted to be a judge, it was decided amongst the partners, there will be testimony to the effect that we thought it would be a good idea for us to sell the building. I had a buyer. The evidence will show that Attorney Shimani Smith had been an attorney that was employed by me for approximately 4 years, and the evidence will show that Shimani and his wife, Audrey, were desirous of purchasing 600 Broadway, and by doing so, purchased Whiteacre North LLC. Remember, the property was assigned to Whiteacre North, and Whiteacre North owned this building and some equipment as its only asset. So what we did is we entered into a contract with the Smiths, and it's called an assignment of membership interests. Please recall that Whiteacre North LLC owns 600 Broadway. Because Whiteacre North, as a limited liability, is not a piece of real property, it's simply a company like a corporation, no deed is prepared. The testimony will be that you're not required to prepare a deed. You're simply required to assign your interests. And you can see when you look at this contract that Attorney Michael Tully, James M. Burge, Susan Cruzado Burge assigned 100% of their interests to Shimani K. Smith and Ajere Morris. You may see that Ajere Morris Smith, or you may see Ajere Smith. The contract speaks for itself. It was to run for a period of 4 years, and it was to terminate on January the 10th, 2011. The terms provide that the Smiths were to refinance the building and pay a sum of cash to Attorney Tully and to my wife and to me. The document was executed by all of the contracting parties. And this is in 2006. Now, thereafter, Whiteacre North, pursuant to this contract, was owned by the Smiths. The evidence will show that the office building was a going concern and that they ran it successfully from January of 2007, sold it on the 11th, all the way up through 2011. In the year 2011, I assigned all of my interest in the property, Whiteacre North, that owned the building, to my wife, Susan. Now, pursuant to the contract that you just saw, the Smiths were to be in the building for 4 years. What occurred was the following. The testimony will be this, that instead of recouping our interest in Whiteacre North, because all of the obligations were being met, and that's what the evidence will demonstrate to you. And because, as you may recall, in 2010, the real estate market was depressed, the Smiths weren't able to refinance. The decision was made to leave them there. And they stayed in as owners until December of 2011. In fact, the records from the Lorraine National Bank will show you that in the year 2011, all of the rent was paid either to Whiteacre North or directly to Shimani K. Smith as the owner of the building. The evidence will be that it was our right to take the property back, but we also had the right to leave him there as an owner. Now, some reference has been made to signature cards at the bank. Signature cards at the bank, the evidence will show, are not an indication that you own the business that owns the account. In December 2nd, 1997, the evidence will show that my wife and I, Susan, and Attorney Tully and Attorney Bradley each signed a signature card so that all of us could sign checks. Later, in 2005, we signed, again, you can see it in the evidence, so that one of the secretaries could sign checks. Then, in March of 2007, though we would have, of course, had the right to force the Smiths to give a new account, the evidence will show that my wife and I and Attorney Tully permitted the Smiths to use the same Whiteacre North bank account that had been used by us throughout the years. And so each of the persons who were the owners and the transferors were required to sign a signature card so that Attorney Shimani Smith could use the account. Ladies and gentlemen, all of the Lorain National Bank records will be before you, and the evidence will be, I'm certain that I never signed a check in my life with respect to that account. Not before, during, or after 2011. Now, as I indicated to you, in June of 2011, while the Smiths were still in the building, collecting rent and paying bills, I assigned my interest in Whiteacre North to my wife. It's a simple affidavit. I, James M. Burge, assign all of my interest in Whiteacre North Limited. Sometimes you'll see an LLC written Limited, and I assign it to her. Please recall that the assignment of an interest in a limited liability company is not the transfer of real estate, so that you don't need a deed. You can simply make an assignment of your interest in the company, because this is simply a transfer of personal property. It's not recorded anywhere. Subsequent to that, a letter from my attorney indicating that my interest in Whiteacre North had been terminated. And this is from Attorney Robert Ellis, a witness, Hersher and Panza. He will testify before you in this court. Finally, in January of 2012, in this case, Susan C. Burge et al., that's kind of a Latin expression for other people, Susan Burge and Michael D. Tully versus Shimani K. Smith et al. Would have been Ajere Morris Smith. And you can see here that Susan and Mike were granted a judgment against the Smiths. That was a judicial determination, for a determination by a judge that they had breached the contract. Now, Attorney Donahue referred to mistakes that I made. The evidence will show, ladies and gentlemen, that the only mistake that I made was believing that as soon as the Smiths didn't pay the balloon note at the end of the term of the contract, the property didn't automatically revert. It would only revert, the evidence will show, if we evicted the Smiths from the premises and recaptured the building. First, we would want a judicial determination of breach, and then recapture the building. The evidence will show that this never occurred in 2011. The evidence will be that the Smiths were the owners of the property throughout the entire year. And when I said that there was a reversion to me, that was a mistake. With respect to the other mistakes that were described to you, the evidence will show that I didn't make them. But in believing that I automatically owned my own building after a simple breach of the contract, I was in error. The evidence will show that I was in error when I advised the Supreme Court. I was in error when I advised Prosecutor Will, and I was in error when I made the same statement in answering an affidavit of prejudice filed against me by Attorney Will. Now, in that same regard, again, the bank records will demonstrate ownership by the Smiths, and as well, the tax returns for 2011 and 2012 will show that I was not an owner. Now, based upon that evidence, I've been charged with having an unlawful interest in a public contract. To prove the offense of an unlawful interest in a public contract, Attorney Donahue is going to be required to show that I authorized a contract in which one of my business associates had an interest. The judge will describe to you what a business associate is, but the evidence will show that it's not someone else's tenant. Lawyers who leased space at 600 Broadway through Whiteacre North, many of them practice criminal law, and the evidence will show that they accept assignments to defend indigents in criminal cases. The evidence will show that upon completion of the assignment, the case is finished, they submit a fee bill to the judge. It's the judge's duty to look at that fee bill, to determine if the hours are reasonable for the work performed, to make sure that the attorneys have not charged more than the county commissioners will permit, and as best we can to make sure that all of their arithmetic is correct. If we determine that, we sign the fee petition. The evidence will show that it goes to the auditor. When you look at the fee petition, you will see that there is a court order, in this case relevant to me, by me to pay the assigned counsel. Now, that is a public contract, and I have authorized a public contract because the service is performed for the county and it's paid for with county money, public money. So it is a public contract. The issue is, were any of those tenants of the Smiths my business associates? The evidence will show that they were not, and therefore these counts will have to fail. Counts 3, 7, and 11, actually we're only dealing with 4 counts now, not 6. 2 counts have been dismissed. The allegation is that each time I approved a fee petition, somehow or other, something was paid to me. Now, the evidence will show the first element. I'm a public official. Approving a fee petition is part of my public function. It's a function for which I'm paid a salary, and I'm not allowed to receive more than that. A better example will be the common pleas judges, with dispensation from the Supreme Court, can perform marriages. The evidence will show, I will testify that I performed a lot of them. In addition, I will testify to you that every time it occurs, someone wants to hand me a check. Well, performing a marriage ceremony is a public function. I'm already paid a salary. I cannot receive additional compensation for performing a wedding, because that's part of my job, if I choose to do it. Now, when I authorize payment to the attorneys performing assigned counsel work, I simply order the auditor to pay them. Attorney Donahue will not be able to present any evidence that I ever received a cent, ever, nor ever asked for one. What counsel did with their fees, I don't have the faintest idea, because they were free to do with their fees what they wish. As Attorney Donahue told you, I'm also charged with 6 more counts. Counts 1, 5, and 9 of the indictment charge me with falsification. And the claim in these charges is that when I filled out my financial disclosure documents telling the Supreme Court about the property and investments that I own and all of the debts that I owe, that I knowingly lied on the form. Let's see if I did. This is my financial disclosure form for 2011, and it describes the property that I own, the debts that I owed during the year 2010. It's 2011 for 2010. It's like your tax return you filed in 2015 for the year 2014. That's me, James M. Burge. Attorney General's been kind enough to redact my personal information, but this is a true copy of my form. Now, question 6 on the form asks me, what investments I held in the year 2010. I listed Sirius XM satellite radio because I have a few shares of stock. I have 4 or 5 shares of stock in American Telephone and Telegraph. You can see item C here. I have highlighted this because this is where the state of Ohio would have expected me to put the name Whiteacre North LLC. But under the terms of the contract that I showed you, you can see that in the year 2010, the Smiths were still in the building, they were still the owners, then operating it correct, collecting rent and paying bills. And so the Whiteacre North LLC at that point was not an investment of mine. Question 6 on the form, 7, I'm sorry, deals with my creditors. And here, I clearly admit that I made an error. F, the evidence will show that I should have listed Lorraine National Bank. Remember, Lorraine National Bank holds the mortgage on 600 Broadway, Lorraine, Ohio, which is owned by Whiteacre North LLC. And I should have put Lorraine National Bank there. The evidence will show that I didn't leave it out purposely, but the evidence is clear that I didn't list it. the evidence will show, and I'll demonstrate in a few minutes, that I listed it every other year. Now, it also asked me in 2010, did anybody owe me money? Well, I listed Shimani K. Smith and Ajare M. Smith, and even that might have been a mistake because their note wasn't right yet. It wasn't payable yet to me. Nevertheless, I listed them as debtors. Then I was asked to list if I own any interest in real estate. Now, I didn't list Whiteacre North here because Whiteacre North is not an interest in real estate, it's an interest in personal property. I didn't list Whiteacre North here, secondly, because in 2010, again, the evidence will show that the Smiths were in the building, collecting rent, paying bills, and operating as owners. I'm also charged with falsifying, making false statements, lying to you in my financial disclosure form in the year 2012. And in the year 2012, I'm supposed to tell you, I'm required to tell you what I own and who I owe in the year 2011. Here, once again, this identifies the form as being mine, James Burge. And let's see what they asked me and if I told them. Sometimes these questions are different, you'll see, as the years go by. At question 1, what were my sources of income in 2011? I list my income as a judge. I list my income from about $25 worth of stock dividends from AT&T. But here, where the Attorney General might expect me to list Whiteacre North, LLC, I list nothing because Whiteacre North, LLC, a limited liability company, paid me nothing in the year 2011. I'm also asked in the same form, do I have an ownership interest in real estate? I did not at that time. Again, Whiteacre North LLC is not real estate, it's personal property. And besides that, as I've indicated earlier, both the bank records and the tax returns will prove to you beyond any doubt that through the entire year of 2011, Ajare and Shimani Smith were the owners of the property. You'll see their names on all of the checks written by the tenants, and you will see that all of the bills for the building are paid by the Smiths. I had no interest in it. Here, I catch up with myself. I list Lorraine National Bank because I owe Lorraine National Bank for the mortgage on 600 Broadway. Do I have debtors? At this time, I had Shimani K. Smith and Ajare Morris Smith. And however, the evidence will show that I assigned my interest not only in the contract, but in their note to my wife before the property was recovered. So this is actually a mistake. This time they didn't owe me anything. Now they owed my wife, and they're on there, but they didn't owe me a cent. Next, question 8, my investments. Sirius Satellite Radio, some common stock, AT&T. I've highlighted space C because that's where Attorney Donahue would have expected me to list Whiteacre North LLC as an asset. However, because it was owned by the Smiths, I didn't, and in fact, I couldn't. And then finally, see that when I filed in 2012, of course, I signed my name and I signed the date, and I determined that I've answered every question truthfully. Now, I'm also charged in this indictment with falsifying my 2013 financial disclosure document. Here we are, 2013 for 2012. Identifies me as the person who is filing. Let's see what they asked me and we'll see if my answers were true. Sources of income, I received nothing from Whiteacre North LLC, so I didn't list any income. Do I own any real estate? At that time, I sold my home, I didn't even own real estate. The evidence will show that that question was answered truthfully. Next. Question 6, do I have creditors? Yes, I do. And there you'll see Lorraine National Bank. They hold the mortgage on 600 Broadway. Even though I don't own the property, the bank doesn't care. I still own the bank. I still owe the bank. So I list that as a debt. At this time, Mr. Smith would have owed my wife some money. Mrs. Smith, the evidence will show, had gone bankrupt. Finally, investments. Because I was not an owner, I did not list Whiteacre North as an investment of mine. It's interesting here too, because you only have to list investments that are worth more than $1,000 net value. If I'm to take Attorney Donovan at his word, Whiteacre North wouldn't have been worth over $1,000 at that time. But since I did not have an ownership interest in it, I was not required to list it. Now, Attorney Donahue indicated to you that there have been disputes between Lorain County Prosecutor Dennis Will and with me. The evidence will show that we've never had a cross word, but the evidence will show that Attorney Will does not appreciate the way I rule on his cases. That goes to your question, which I'm sure is in your head. Jim, if you're innocent, why are we here? Well, Attorney Donahue gave you part of the answer.
Overruled, just a second, go ahead.
Attorney Donahue gave you part of the answer, and the evidence will show the rest. The evidence will show that the Attorney General's office is not quite as objective as you might think.
Objection. Sustained.
The evidence will show...
Let's not give argument at this point in time, just what the evidence will show.
The evidence will show, ladies and gentlemen, that in the 7 years plus a little bit that I've been on the bench, Attorney Will has filed 6 affidavits of prejudice against me that have me removed from cases. He has filed 20 grievances against me.
Objection.
Overruled. With the disciplinary council. In his last affidavit of prejudice, the evidence will show that it was a 68-page document. It was filed with the Supreme Court. And the evidence will show that it contained the same complaints that you're hearing in court today, and allege that I was biased against Attorney Will. He asked the Supreme Court of the state of Ohio to remove me from all of his cases. 278 of them. Well, when the ruling was finally made...
Let's not discuss that. That's not relevant in this case.
The evidence will show that my docket was returned to me.
Yeah, keep that straight. Juries disregard the comment.
Now, In answering that affidavit, and in answering other inquiries of me about the property at 600 Broadway, because I was mistaken about when the Smiths actually terminated their ownership and operation of the company, when I wrote on my own behalf, I made mistakes. Because I believed that we probably owned the property as soon as there was a breach without having taken control of it or receiving any judicial determination of their breach. The evidence will show, ladies and gentlemen, in making those statements, I was dead wrong. The evidence will also show that at the time that I was indicted, Attorney Donahue had in his file.
Objection, Your Honor.
Sustained. Let's deal with the evidence that are relevant in this particular case.
The evidence will show that at the time that this matter was presented to the grand jury,
Objection, Your Honor.
the state of Ohio knew I had made a mistake. And what occurred is that when this 68-page affidavit, prejudice against me, attempting to disqualify me from the prosecutor's docket, failed, I was indicted.
Objection, Your Honor.
Sustained. Let's get off this line, please, Mr. Burge. Let's discuss this line.
Ladies and gentlemen of the jury, after presenting all of this evidence, I think your question was a good one. I would read your minds probably. Why are we here? You're so innocent. During the course of this trial, you're going to find out. Thank you.
Thank you. We'll go ahead and adjourn until 9 o'clock.